Okay, let's talk about hearsay. It's one of those rules in evidence law that has a reputation for being, well, a bit of a nightmare. But if you're a law student, you absolutely have to get your head around it. So in this explainer, we're going to break it all down and give you a modern, practical guide for criminal cases.
Right, here's how we're going to do this. First, we'll look at the old school, classic rule to see why it was so problematic. Then, we'll see how it got a massive modern update. After that, we are going to zero in on the single most important definition you need to know. We'll make it all click with a really simple example, and then finish up by giving you an essential toolkit you can use every single time.
So to really get a handle on the modern rule, you have to understand the problem it was designed to solve. And that means we have to start with the old common law rule against hearsay. Think of it as this huge, sweeping rule that just blocked a ton of evidence.
And here it is. This is the classic definition from the textbook Cross. What it basically said was, if a statement wasn't made right there, in court, under oath, by the person on the witness stand, you just couldn't use it to prove that what it said was true. Simple as that. Inadmissible. So, you might be wondering, what was the big deal? Why did the courts distrust this kind of evidence so much? Well, it really came down to two main things. First, no oath. The original statement wasn't made with the same seriousness as sworn testimony. And second, and this is the big one, no cross-examination. You couldn't challenge the person who actually made the statement. You couldn't test their memory, their eyesight, or if they were even being honest.
So the bottom line? This old system was just too rigid. It was so technical that it often forced courts to throw out perfectly good, reliable evidence. And that, of course, could lead to serious miscarriages of justice. The whole thing was becoming, as folks said, absurdly technical. It was clear that something had to give.
And that's when this major piece of legislation comes into the picture, the Criminal Justice Act of 2003. This act didn't just tweak the old rule, it completely reformed the whole landscape of hearsay in criminal law.
Now, what's interesting is the act didn't just get rid of the hearsay rule. Instead, Section 114 put it into statute. It says hearsay is still generally inadmissible unless it can get through one of a few specific gateways. Think of these as special doors that can let the evidence in, like if there's a specific law that allows it or if it's in the interests of justice.
But here is the real game changer. This is the most brilliant part of the act. It didn't just create more exceptions, it fundamentally changed the definition of what hearsay even is, making the rule much, much narrower. And understanding this shift is everything.
Which brings us right to the heart of the modern rule. Today, it all comes down to understanding the meaning of one little phrase in the act, a matter stated.
This is the million-dollar question. Before you can even think about those gateways or exceptions, you have to figure this out first. Is the evidence you're looking at actually trying to prove a matter stated?
And thankfully, Section 115 tells us exactly what it means. And this, right here, is the absolute key. A matter is only stated if the person who originally said it or wrote it intended for someone to believe it or to act on it. The whole focus shifts from the words themselves to the purpose of the person who said them.
Seriously, if you only remember one thing, make it this. Under the modern hearsay rule, it is all about the purpose. Why did the person make the statement? That one question is the key that unlocks this entire area of law. I know this can feel a bit theoretical, so let's make it super concrete.
We'll use a dead simple example to show you exactly how this focus on purpose works in the real world.
Okay, picture this. A witness is on the stand, and they want to tell the court that they heard some other guy, let's call him X, say the words, "I went to London yesterday." Now, is that statement hearsay? Well, the classic lawyer's answer applies, it depends.
It all comes down to why you want to use that statement in court. If your purpose is to prove that X really did go to London, then you're trying to prove the truth of the matter stated. X's purpose was to make you believe that, so bam, that's hearsay. But what if your purpose is completely different? What if you just want to prove that X can speak English? Well, in that case, you don't care if he went to London or the moon. All that matters is that he said the English words. That is not a matter stated, so the hearsay rule doesn't even kick in. We call that original evidence.
So, how do you apply all this when you're faced with a tricky problem? Well, the good news is the Court of Appeal has actually laid out a clear, step-by-step test that you should use every single time.
And that test comes from this hugely important case called RV Twist. This is the definitive, authoritative approach. So whenever you think you might be dealing with hearsay, this is the framework you need to pull out.
The test is basically three questions. Step 1. What's the fact you're actually trying to prove to the court? Step 2, look at the statement. Does it actually contain that fact? And step 3, the big one, was it the purpose of the person who made the statement to get someone else to believe that fact was true? If your answer is yes to all 3 of those questions, you've got hearsay. But if the answer to question 2, or, crucially, question 3 is no, then it is not hearsay and the rule just doesn't apply.
All right, so let's just quickly recap the absolute essentials. First, hearsay isn't really a type of evidence. It's a rule about how you can use evidence. Second, the Criminal Justice Act totally changed the game by narrowing the rule to focus on the maker's purpose. And finally, when you need to apply it, your go-to guide is that 3-step test from the Twist case.
And that leaves us with one final big-picture question to think about. This new focus on purpose is much clearer, for sure. But one of its consequences is that it pretty much removes so-called implied assertions from the hearsay rule. So while the law is simpler, we have to ask, does leaving that kind of evidence unprotected create new dangers for a fair trial? That's a really important point to chew on as you go deeper into this stuff.